Let's bring you this now. The Supreme Court of Appeal has made a new ruling about owners of homes in estates. It settled the debate about the issuing of fines and penalties for breaching body corporate rules. Let's get more insight on this now with property analyst Mamodupi Mohlala. Mamodupi, thank you so much for your time this morning. Good morning. So update us on this new ruling by the courts with regards to homeowners in estates as well as home associations.
Thank you very much, Dumelo. Good morning to yourself and good morning to your viewers at home. Yes, Dumelo, there has been a landmark ruling that was issued by the Supreme Court of Appeal a few days ago in the matter of Mount Edgecombe Country Club versus Singh. In terms of that ruling, the Supreme Court of Appeal puts to rest the issue of whether or not body corporates can include penalties and fines in terms of levies. The court has held that the body corporate can include that so long as it's encapsulated in the memorandum of incorporation of the body corporate and also included in the rules of the scheme of the body corporate. So now it is law that a body corporate can issue any penalties and and fines, and if not paid by the homeowner, those can be included in the levies.
Yeah.
And if that homeowner does not pay it in terms of the levies, the body corporate then does have the right to deactivate their rights of access to the estate.
When we talk about penalties and fines, what are we talking about here specifically?
Okay, maybe what would be easiest is for me to refer to the facts of this particular case.
Right.
In this particular case, it related to an estate, a luxury estate in KwaZulu-Natal, in terms of which the homeowner was issued with 3 penalties in 2013. In fact, his daughter was issued with penalties, in terms of which third parties had actually exceeded the speed limit as specified in terms of the rules of the scheme. In terms of that, in terms of the rules of the body corporate, the speed limit was supposed to be 40 kilometers an hour. The visitors of the daughter had exceeded that speed limit. The body corporate had then issued penalties and insisted that the owner should pay those penalties. The owner refused to pay the penalties. It firstly went to the High Court in KZN. The High Court held that that this is a public road, and as such, the body corporate did not have the right to impose those penalties. The body corporate or the Housing Owners Association then took the matter on appeal to the Supreme Court. The Supreme Court firstly ruled that a road in an estate is not a public road, it's a private road, but most importantly, it indicated that the relationship that exists between the owner and the body corporate is a contractual relationship. And if in terms of that contractual relationship, there is a clause that specifies that they shouldn't breach certain rules, and they breach those rules, penalties can be imposed, and those are legal penalties that will be encapsulated in the levies.
Yeah, I'm glad you raised the question about, whether the road within an estate is a public or private road, because that was the question that kept coming up, right, during arguments. But also the question was around whether the roads will then have to comply with the National Road Traffic Act if it indeed makes it a public road.
Yes, but I believe that the Supreme Court of Appeal has been clear on that it remains a private road, and that it must be understood that the liability for the penalties does not emanate from whether or not the road in an estate amounts to a public or a private road. But the liability emanates from the fact that the homeowner and the body corporate are bound by the memorandum of incorporation, but over and above that, they are bound by the rules of the scheme. So the rules of the scheme are quite critical. They will determine where penalties lie, how they must be imposed. So it's quite fundamental. And I think the lesson that must now be learned by owners in relation to this judgment is that they need to be very conscious around the rules of the scheme.
Right.
When amendments are undertaken in terms of the rules of the scheme, they must pay attention, because those will have an impact with regard to their relationship going forward with the Homeowners Association or the body corporate.
Mamodupi, in the last seconds I have with you, so obviously the fines then would have to be lodged and penalties would be lodged, and you'd be liable to pay when you pay for your levy, I suppose at the end of the month in this instance. What amount are we talking about here? Does it vary per estate, per body corporate?
Yes, no, there would obviously, you'd expect that there would also be a tariff. Once the rules of the body corporate say these are penalties, then there should be a tariff that's attached that speaks to the amount of the penalties. In the Singh case, the amount was 1,500 per transgression, but it will vary from body corporate to body corporate depending on the schedule that is attached. So I believe that homeowners must also insist that the schedule of fees also be provided so that they can know in advance what penalties amount to.
All right. Well, I appreciate you speaking to us about this and simplifying it for us. Property analyst Mamodupi Mohlala, thank you so much for your time. So there you go. Just be careful with all the rules and regulations that govern the estate or even complex that you reside in. You could be liable for a hefty fine should you bridge, any certain, rules of the estate, particularly if you're speeding within, the estate. Now regarded that you could be fined and they could be attached to your levies and you'd be liable to pay them at the end, of course, of the month when you do receive your statement. So thank you so much for Mamodupi for giving us that insight.